Can the functionality of a computer program or the programming language be protected by copyright? If you do not have the patience to see this video until the end, the answer is no. About this topic, let's see what the European Court of Justice recently held. SAS Institute Incorporated has developed the SAS system, an integrated set of programs which enables users to carry out data processing and statistical analysis. World Programming Limited, WPL, produced the World Programming System, WPS, which emulated the functionalities of the SAS components. As a consequence, users of the SAS system are able to run on WPS the scripts which they have developed for use with the SAS system. In order to produce the WPS program, WPL lawfully acquired copies of the learning edition of the SAS system, supplied under licenses, limiting the rights of the licensee to non-production purposes. So WPL used and studied those programs in order to understand their functioning. According to the documents available, WPL had no access to source code of SAS system. SAS Institute Incorporated brought an action before the High Court in the UK, accusing WPL of copyright infringement related to the SAS system manuals and components and infringement of the terms of the Learning Edition license. Afterwards, the High Court has put question to the Court of Justice regarding the scope of the legal protection provided by EU law on computer programs. Remember that the following is based on the fact that the defendant, WPL, had no access to source code of the software. The court recalls, first, that the directive on the legal protection of computer programs extends copyright protection to the expression in any form of an intellectual creation of the author of a computer program. Ideas and principles which underlie any element of a computer program are not protected by copyright EU law. Hence, only the expression of those ideas and principles is protected by copyright. And such expression is the source code and the object code. On the basis of these considerations, the court held that neither the functionality of a computer program nor the programming language and the format of data files used in a computer program in order to exploit certain of its functions constitute a form of expression. Therefore, they do not enjoy copyright protection. Second, the court observes that, according to the directive, the purchaser of a software license has the right to observe, study, or test the functioning of the software in order to determine the ideas and principles which underlie any element of the program. Any contractual provisions contrary to that right are null and void. Lastly, the court holds that the reproduction in a computer program or a user manual for that program of certain elements described in the user manual for another computer program amounts to be a copyright infringement only if the reproduction of the latter manual constitutes the expression, again, of the intellectual creation of the author of the manual. In this respect, the court notes that in the present case the keyword, syntax, commands and combinations of commands, options and so on consist of words, figures or mathematical concepts that taken in isolation are not as such an intellectual creation. It is only through the choice, sequence and combination of those words, figures or mathematical concepts that the author expresses his creativity in an original manner. If you want to know more about this decision and its impact on the Italian market, contact me directly or leave a comment, check out our blog and follow, obviously, our Lawyers Monday.